Sorry, I just meant that I was going to open it up. I think we'll wait just a couple minutes before we officially start rolling.
Okay, and then I just clicked record
Oh, good.
to make sure that we have it recorded.
Okay, thank you. I like your spiel.
Yeah, I printed it from. It's an actual script that I printed from GoTo.
Nice. Okay. So up where it says audience view on my thing, it says it's divided. Does that just mean because I have the split screen?
Yes.
Okay,
Yep.
great.
Because you have the video.
Yep. Okay,
The web,
perfect.
so I can see the PowerPoint,
Okay, and we'll start the webcam.
and I can see you're at the top of the PowerPoint.
Okay, great. You notice how terrible your posture is when you're on video. Mhm. So did you say you're already recording?
Yeah, I can stop. It's probably a good idea to.
Hello, everyone. Thanks for joining us today. Um, we are presenting the topic today about advocacy versus unauthorized practice of law. Um, uh, as advocates in the field, you are going to have survivors working on a lot of different kinds of civil cases. And so this is a question that comes up a lot. How far can you go in your advocacy? Where's the line? And we're going to try to figure that out today. So thank you for joining us.
Sorry, my thing. Do we want to start it over? Let's do this. I think
Okay.
my mic was on mute. We'll start.
Okay.
All right. I want to thank everybody for joining today's presentation. I'm no lawyer, but today's presentation is brought to you by the Iowa Coalition Against Domestic Violence. Today's presenter is Elizabeth Albright Battles. Elizabeth is an attorney at law here at the Iowa Coalition Against Domestic Violence. And my name is Charles Hoffman-Zinnel. I'm the online training specialist here at the Coalition, and I will be the moderator for today's webinar. Before we get started, I want to review a few things, a few housekeeping items. If you have a question, go ahead and raise your hand in the attendee pane. You can raise and lower your hand. That will inform myself or Liz, that you need assistance with a question. You can also go ahead and type your question in the chat pane at the bottom. There are also handouts available. There's one PDF handout, which is at the bottom of your control panel. So before we get started, do we have any questions for Liz? No questions. At the end of the presentation, we'll do a short Q&A. This will allow you to ask questions. So I guess we'll go ahead and start, Elizabeth.
Great. Thank you, everyone, for joining us. I'm also open if you have questions as I'm going through with something. You can type it in the chat box, and Charles will try and draw my attention to it, and we'll see if we can fold it into what I'm talking about as we go. Um, so our topic today is about unauthorized practice of law versus advocacy. This is a question that comes up for advocates a lot to try and figure out how much they can do, what can they say to a survivor who's working on a civil case, and trying to figure out when that advice goes over the line and becomes unauthorized practice of law. So just to tell you who I am and why I'm talking to you today, this is the second in a Lunch and Learn series that the ICADV Legal Clinic is putting on to try and provide continuing education and more information to advocates out in the field who are working with survivors. I am an attorney here at the Coalition. I've been with the Coalition since 2009. I am the Skylark Project Director, so I work with incarcerated survivors of domestic violence. And then I'm also a co-director of the ICADVA Legal Clinic. So I have worked with survivors in a number of different civil legal cases, um, primarily divorce, family law, and protective order, but I've dabbled in some other areas. Um, so we're going to try to walk through what is unauthorized practice of law, and then at the end we'll get to some hypotheticals, so you can actually think through daily application of the information that we're talking about. And when we get there, I really do want you to participate and give me some feedback. So here we go. So as an advocate working with domestic violence survivors, you've probably already seen that DV survivors are involved in the court system in lots of different ways. There's all kinds of civil cases that you may have come across. These are some of the biggest ones. Divorce and custody come up a lot. Certainly immigration is a very common issue among undocumented survivors or survivors who have their immigration status tied to an abusive partner. And then 236 protective orders, I imagine most of you have walked through that process. Housing and eviction is one that advocates are addressing more frequently now that we're looking at a housing first model and trying to address housing needs more directly. But there are lots of other topics that may come up for survivors as they're working with you. Some of the ones that you may have seen would be discrimination. That could be employment, that could be housing. There could be other employment issues. You know, maybe someone has a civil protective order and then they're let go from employment because it's too difficult for the employer to accommodate. Disability. A lot of survivors who reach out to our programs may be eligible for Social Security disability insurance, disability payments from the government, or they may have, you know, they're trying to get their employer to accommodate a disability, all of those things. Title IX cases, if you work with people who are students either at the university level or in primary and secondary education as well, equal access to education. And then civil tort suits, if you have survivors who are suing abusers for their violence, that would be things like emotional distress, injury, those kinds of things. So lots of different kinds of cases that survivors may be struggling with and may have questions about while they're working with you. So what that does as an advocate is put you in this kind of tricky spot. You have the push-pull of you want to support them in their case, you want to empower them to be able to do the best that they can. That's advocacy. And then you have to watch out that you don't tip over into what would be considered unauthorized practice of law. There are some rules around that. There are risks involved if the information that you're providing could be construed as legal advice. So it's this tightrope. You're trying to figure out how much you can provide and where you have to say no. And as an advocate who's been in practice for any amount of time, I'm sure you've also seen attorneys who do a really good job and attorneys who do a really bad job. And so you may find yourself playing a little bit of pickup. So it's very important to try and figure out where this line is. 236 protective orders will have their very own lunch and learn in our series, so I'm only going to touch on them briefly today. But for our purposes, they're important because there's a special order from the court that enables advocates to provide this broad range of services, and it specifically protects advocates from a claim of unauthorized practice of law in that 236 process. So things that an advocate can do when a survivor is applying for a civil protective order under Iowa Code Section 236. The victim counselor can distribute forms, can assist with the pro se process, so filling out those forms, getting in touch with the clerk of court, all of those. You can describe the proceedings. You can let the survivor know what to expect, how testimony will flow, what kinds of things the judge will be looking for. And then you can accompany the victim through all stages of the proceeding. So you can sit at counsel table during the hearing. You can go into the judge's chambers at the temporary protective order stage, or if a survivor wants to go back and amend or dismiss the protective order. So it's a pretty broad range of activities, and I'm sure that many of you have done that, have walked with a survivor through that process. As a side note, this special protection is only available within the context of your employment. So if your next career is outside of DV, you no longer have this protection. So, if you become a teacher or something, or you go to work at the DHS office, you are no longer allowed to provide this service where you are helping someone fill out the forms and you're going to court with them. Similarly, even while you're employed with a DV program, you are not technically protected in your off hours. So say, for example, your brother is going through a divorce and needs help, needs some protection. Your brother should be working with a different advocate for a number of ethical reasons, but in your off hours, you are just a family member. You are not an advocate on the clock. So a small thing to watch out for there. Even with the special protection that's allowed by that court rule, advocates in the 236 process may not give legal advice. You may not examine witnesses, and you may not make arguments to the court. At the judge's discretion, you may respond to the judge's questions, but you can't stand up and yell objection. You can't say, hey, sit down, let me explain to the court what's going on here. You are not allowed to act in a representative capacity. The court really wants you to be a guide through that process rather than a representative. So that's a very quick look at 236. Generally speaking, what is unauthorized practice of law? The hard part is that the practice of law is a really fuzzy concept. It's hard to pin down exactly what it is. The court has not come up with a single clear definition. Generally, the practice of law is about the exercise of discretion, the interpretation of the law and the application of the law, and practicing before the court. So there's this quote I included here from a case about unauthorized practice of law, where the court describes the exercise of professional judgment on a legal issue or question that affected the rights of a third party. So that's a pretty broad definition. Unauthorized practice of law does not restrict somebody from representing themselves. So if you had a claim that you needed to pursue in court, you could still march in and represent yourself there. That's exactly what you see many of the survivors do that you're working with. Unauthorized practice of law is really concerned about when you are doing things that affect someone else's rights. So you're providing them with information or acting in a way that someone else's rights are going to be injured rather than your own. Attorneys have a little saying that even among attorneys, it's very uncommon to represent ourselves just because it's very complicated. And the saying goes that the attorney who represents himself has a fool for a client. It's hard to understand the law, and it's complicated when your own emotions are mixed up in what you're trying to achieve. I'm sure you've seen that happen with your pro se clients. So the law is really trying to protect when that person reaches out to someone else to have them help. They want to make sure that the person they're reaching out to is someone who's trained and understands the law as an attorney. So as I said, unauthorized practice of law concerns are meant to protect people from getting poor advice. If my best friend from high school is a librarian and she tells me that my husband won't get custody in my divorce, I know she has no basis for that opinion beyond her own personal opinion. I know she doesn't have any special training or experience or anything like that. If my advocate tells me the same thing, I might think she has special knowledge. Advocates are in a position of power and authority. You know your clients have seen you get action where they could not in all kinds of scenarios. You hold lots of specialized knowledge. And the people that we're working with are desperate. So they're looking for anyone who can offer them guidance through these really hard and scary things. So your position makes it likely that someone is going to put more weight in your opinion than their best friend from high school. Okay. Your clients may see you as sort of lawyer adjacent. So you have to be more mindful of creating a clear distinction between what you know and what a lawyer would know. So these are some broad examples of what unauthorized practice of law would look like. So things like giving an interpretation of a statute or case law. So if you have a client going through a divorce and she wants to know how domestic violence can be used in her case, why should she bring up domestic violence in her divorce? She may look at the code and see that there are ways that a history of divorce, history of domestic violence can be useful. If she brings that to you and shows it to you, you can't really, look at that and say, well, that means that here and here and here and here, you want to bring that up, and this is how you establish a history, and because that would be an interpretation of case law or an application of the case law to her specific situation. Similarly, drafting court documents or official letters on someone's behalf would be considered the practice of law. So if a client needs a motion to continue, you can maybe help her search for examples, but she has to come up with the language herself. She has to come up with the explanation for the need, and she has to file it. Explaining someone's rights and options to enforce them. Again, 236s are sort of off to the side, but more generally, explaining to someone how the law applies to their situation is going to be a very tricky situation that's best left to an attorney. Similarly, advising someone how to act. So, if someone wants to flee the state with her kids and you're trying to help her decide whether or not that's a good decision, there's a lot of laws that come into play there. And so that you can't give her advice about that. You can help her weigh pros and cons, and you can help her get in touch with attorneys in both places to walk through that, but that's not something where you want to give an absolute. So what's the risk, right? If I am an advocate and I don't have that legal training and I, maybe my client who wants to flee the state, she has a really dire case, no judge in their right mind would make her stay with the kids. What's the risk in me telling her that she should get out? Well, there could be damage to someone's legal rights. So if someone follows your advice and, for example, flees the state, she could be potentially charged with kidnapping if it meets certain requirements. It could damage a custody and divorce suit as to, it looks different to the court if the survivor comes and asks for permission, asks for help, versus if someone flees into the night and is trying to stay under the radar. It's a very different posture for that survivor to walk into the courtroom and try and explain to the court what's going on. And you never want to damage a survivor's legal case. I know that, you know that. So this is very serious to think through. There's also the potential of a civil suit. So if a survivor's case was damaged because of bad advice, her only possible defense in an appeal might be that she got legal malpractice, unauthorized practice of law kind of advice, and so the court needs to give her a second chance. And that would also give her space where she might sue for civil damages. If she loses custody of her kids, or if there's something like lost wages, as she's if she has jail time, emotional distress from separation from her children, or exposure to violence. And then there can also be sanctions by the Commission on Unauthorized Practice of Law and the Iowa Supreme Court. The Commission, there's a specific branch of the Attorney Regulatory Division that deals with unauthorized practice of law, um, and they could issue sanctions. Those are more embarrassing than meaningful for people who are not lawyers, but it's still a problem, and your agency would not fare well. It'd be embarrassing and public relations nightmare and all of that. So even though the stakes are high, please don't let unauthorized practice of law stuff rattle you. My goal is that you know the stakes and you're aware of your power as advocates so that you can remember to think critically and to speak with purpose, to think through what's the impact of my words, how is someone going to view what I'm presenting. There's still a ton of really important stuff that advocates can do to help survivors who have legal cases. This is a list of some of the broad things that advocates can do. So helping her identify and hone her goals. This is an ongoing process. So before she meets with an attorney, as her knowledge and her understanding of her options grows as the case progresses, she is going to need some help weighing what's most important to her. If the attorney is saying, well, you could have ABC or EFG, she's going to have to think through the pros and cons there. So if she's seeking custody, what's most important to her about that? That's the kind of question you can ask her. How does she feel about visitation exchanges? You're asking questions to stimulate her mind and get the survivor to think about, am I concerned about them being there overnight or just about them being there at all? Is it a particular person who's at the household? All of those kinds of things to narrow in on what the specific concerns are will make her meetings with the attorney more productive. And if she's paying an attorney, that will make it cheaper too. Maintaining realistic expectations. There are limitations in the court process, so help validate that frustration that this process is not going to be the answer to all of her questions. That she is not going to get the perfect response. There may be, accessibility of attorneys is something that comes up a lot. Survivors, are in dire situations. They are very nervous about what's going on and may push buttons or cross boundaries. You've seen this happen. So if you can help her to figure out those lines, that will help the attorney process be smoother as well. Prioritizing issues and thoughts. So she's going into a meeting with her attorney and she has 6,000 questions. Help her think through what does she want to get to first? What's next most important? That kind of prep work. If there are forms, you can fill in information as directed by the client. You can assist with translation. Witnesses, timelines, evidence. Attorneys might request this or the client might request it, and you can help with that. And then just dealing with trauma and peripheral needs is a huge thing. As an attorney, I have a very limited amount of time with my clients. Because I understand trauma, I try to take additional time to address, the grief that comes with a divorce, to address the sense of lost hope and frustration that comes with realizing your partner is a bad parent and that you don't actually want your kids to spend time with them, but they're going to have to spend time with them, right? Those are huge life questions that are hard to deal with on top of years of abuse and all of the trauma that leaves survivors with. So having an advocate who can help with that process, who can take more time to develop coping skills, to work through those emotions, and then addressing those trauma symptoms as we actually move through the case too. So maybe that's a field trip to the courthouse before trial. Maybe that's working on grounding techniques during testimony, or doing things like making sure she has childcare on the day of trial. so that she doesn't, I mean, the last thing you want is the kids to come to the courthouse. Um, so all of those things are huge and will definitely leave you with enough on your plate. There are some subtle shifts in language that can help buffer the impact of what you say to a client. It can change the advice from being construed as legal into information that provides context and feedback. We know that you as an advocate have a wealth of information that's really helpful to clients. You just have to remain in the zone of empowerment and informing your client rather than giving them advice or direction. So avoid language like you should do this, or here's what I think, or something like that. Framing your language to the client as, you know, in my experience, I have seen a lot of divorce cases do this, or I'm concerned that as you're thinking about custody, you are forgetting that your kids will have to spend time with your ex. So let's talk about that. Let's safety plan. Couching it in that kind of language can help make it seem less like an attorney is giving them legal advice, less like it's about the law, and more like it's about what you've seen happen before and about taking care of emotional needs for that client. You can remind a client that no two cases are the same, and that's important to do if you're talking about what you've seen. The person know that not just because it's happened one time doesn't mean it's going to happen again, because she'll be doing the same thing. You know, pretty much everybody knows somebody who's been divorced and how it ended up in their case. And a lot of people are under the mistaken impression that because when my sister got divorced, this is what happened, that's going to be what happens in my case. And depending on the judge, depending on the circumstances, divorce and custody cases in particular are very heavily fact-based. So it really depends what judge I've got, what information comes out on testimony, what evidence is presented. So it's not going to be the same for every single person. Okay, so now we're going to get into some hypotheticals. We're going to walk through some different examples of cases that may walk in your door and think through what you as an advocate can do to help a survivor in that situation. So the first kind of case that you may encounter with a survivor is someone who just has general questions and is trying to make decisions in her life. She doesn't have an attorney, there's not an active case, but somebody just wants guidance. So there's a whole host of things that you can do as an advocate to help that person. You can weigh pros and cons of various options. You know, what do you think would happen if this happened? Or in my work, I've seen this thing happen a lot. I can't say whether that would happen for you, but let's think about what would be good about weekend visitation, what would be bad about weekend visitation. You're helping the survivor articulate her needs, and then that gives the survivor information to make a decision on her own. You can help the survivor organize competing goals and priorities. You know, sometimes we're complex beings. We want multiple things at once, and sometimes those desires are in conflict. And having somebody help point that out can help someone start the process of deciding which thing is actually more important. You can consider non-legal remedies that you may know about. You know, can the survivor pull on family or friends to help? Does it make sense to involve DHS? Think about other nonprofits that you may be connected to, Disability Rights Iowa or the Brain Injury Alliance, or whatever may be appropriate for the question that the survivor is dealing with. Not everything requires legal intervention to work, and some things are better resolved without the courts involved, if you can have a more informal thing happen. always emotional support for the survivor. Validating what they're going through is hugely important. Um, a lot of attorneys, when you're going through law school, we don't get any training about what is domestic violence, about the impact of trauma, about mental health issues, and very, very little guidance around what to do with clients who have diminished capacity. So people with learning disabilities or um, English is not their first language. Um, so a lot of attorneys don't know how to handle that. And it can be incredibly frustrating for survivors. So anything you can do to help the survivor understand that and help the survivor see that you understand that and that you see what's happening and empower the survivor to ask for what they need is important. You can call ICADVA with hypotheticals and general TA. So that means I can give you some food for thought, or I can give you a general idea of process-wise how something works, or a broad understanding of the law, and that can sometimes help you counsel the survivor about making decisions. So, for example, let's say you're working with Sarah. John and Sarah divorced 2 years ago. Their son is 8 years old and they have joint legal custody. The son lives with Sarah but has weekend and holiday visits with John. John uses his weekend visits but never takes the son on his holidays. On his weekends, John calls the kid fat, tells him that mom takes all his money in child support so he can't take him to the movies, and occasionally John forgets to give his son his ADHD medication. So Sarah comes into your office and says, help, this is making me crazy. John won't follow the visitation order. He won't take his son on holidays. He's only taking him on visits. He's doing all these things wrong on weekends. I just don't know what to do. What do you think you can do to help Sarah in that situation? What would be some advocacy there? I'm going to give you a couple seconds to type some things into the chat box. Give me your thoughts. Do people have any thoughts? Any ideas of what they would do to help Sarah?
Let me see. I think we have a question. What do we got here? Nicole said that's a tough one. She thinks it's a tough question.
It is a tough one. So I would assume that this is a question that comes up a lot in your advocacy. Is that true? Do people see survivors come in with stuff like this?
Yes. Jody says, help mom to cope with what's happening by emotionally supporting her.
Okay. Yes. Thank you, Jody. Exactly. So there's a whole host of things you can do to help Sarah in this situation. Think through my little list here. So validating that co-parenting is hard, right? That people get divorced because they stop trusting the other parent, and now because we are divorced, I have to turn over my child and trust you to take care of my child for a certain amount of time. It's a terrible situation, and particularly with domestic violence, co-parenting becomes an opportunity for manipulation and all of that. So validate, provide emotional support around that. You can also remind her that kids are resilient, that even if his weekends are awful, that her son, Sarah's son, lives with her. Perspective on his life, that the son spends most of his time with Sarah, which is a safe space, and you can help Sarah support her parenting in that time so that she can be that emotional safe space for her son. In addition to that, you can also do things like sort out Sarah's goals. She's wishing that John were a better parent, right? Name that, and recognize that courts have very limited power to make somebody a better parent, that unfortunately no one really has that power. People have to be motivated to do that. Maybe Sarah is voicing that she needs a break from parenting, right? Or is she telling you that she never wants John to see the kid again, right? Help her nail down what her priority is there, and recognize that some of this is in conflict, right? So she wants John to take the son on the holidays, and yet when the son is in John's care, Sarah doesn't like how he's parenting. So you can point out to your client that I'm hearing both of these things, and they're kind of in conflict. So can we maybe look at it and say, thank goodness he's not taking your son on holidays, because you don't like what happens when your son is in John's care. Let's talk about what other options may be around to help give you a break, because every parent needs a break sometime. That's totally normal.
Elizabeth, we have a
Do you have
couple
another
more.
suggestion?
Yeah, we've got a couple
Okay.
more responses. Our first response comes from Taylor. She says, we're the ones to remind the survivor that we will be here through this entire process, no matter what the outcome, and that person can get through this. We can plan activities with them to have something to do while the child is on visits, or encourage self-care. And then Nicole writes, safety plan with the son, with the child advocate.
Great. Those are all great suggestions. Um, those are all very helpful to the survivor to help her feel supported, and help her think through what options she has, where does she have power in her life. You can also think through non-legal options with Sarah. So, would communicating with John directly about any of these things be something that she would see as useful? What would happen if she told him, you know, it's really important that our son takes his ADHD medication. That's about his health. Um, I know that that's fallen through the cracks sometimes. Could you please help with that? Walk through a pro-con of, what would happen if we called DHS? Is that something that Sarah is looking for? Does she want that kind of intervention? From your experience working with DHS, is this a case where they would intervene? It's pretty light on things where DHS could be effective, depending on the medication issue. And in your experience with DHS, you are going to have some sense of how the agency in your area responds, and you can give Sarah sort of a reality check around that if that's something she's asking for. You can refer Sarah to an attorney to look at legal options. You can give her a framework about custody changes, that it's really hard, and that it's an uphill battle, that the court has limited power to change parenting behavior. All of that is stuff that you can say without giving legal advice. You just don't want to stand in the way. If she's saying, I want to talk to an attorney, help her get an attorney. Any sense of what sort of things would be over the line? What would fall under unauthorized practice of law? So one big obvious thing to avoid, you cannot tell mom that she should not send her son for visitation. That is just a straight up bad idea. For a number of reasons. You can't tell someone to break the law, and disobeying a court order in the form of a custody order is breaking the law. It's also the practice of law to tell mom, like, if you didn't send him, this would be your defense. That's a practice of law. You can't go that far. You can't write a letter to John from you or from your agency. If Sarah thinks that it will be effective to communicate with John directly, you can help her by working with her on writing it, by being a sounding board. That is a very delicate process, and a lot of survivors have a challenge where they want to go overboard, or parents in a custody battle pick at each other on stuff. So being a second set of eyes to go through and say, let's think about how he's going to respond if you call him an asshole in this letter. Is that going to get the response that you want? You can help her with that process, but you cannot sit down and write a letter to John from your agency. You also don't want to tell Sarah her chances of winning a modification at trial. You don't want to say, you've got no chance here, or that DHS would definitely find founded child abuse or anything like that. And you can't give a conclusion or a prediction of absolutes in a case, but you can let her know in your experience what you've seen happen, and remind her that every case is different. Okay. So let's think through a different scenario. Let's say a survivor has an attorney. She's working with somebody. There's still a lot that you can do as an advocate to support that relationship and to help the survivor feel heard. One of the really important ones is just comprehension of the survivor. Does she understand what's going on? Does she remember what the attorney is telling her? Attorneys have their own special language, and some attorneys are really bad at translating it or at remembering that not everybody speaks legalese. Or even, saying things like, we've got a temporary matters hearing next week, I need an affidavit. Like, what the heck does any of that mean? What is a temporary matters action? What do I need to do? Do I need to be there? These are all questions that survivors are going to have. Sometimes they're too afraid to ask, and sometimes attorneys are too dumb to explain. So check in with your survivor. What's coming up next in your case? Do you understand what that is? Do you have any questions about how that's going to go? And empower your survivor that it's okay to ask questions, right? She can go back to her attorney and say, I don't understand what you need from me. Help the survivor plan for attorney meetings. So maybe, in a week she's meeting with the attorney to talk about settlement proposals, right? What are they going to offer to the other side to settle the divorce? You can help her think through her priorities, what's most important, what questions does she have. Keep realistic expectations. We talked about some of these briefly. Coming up with timelines of abuse. Sometimes that can be helpful if a survivor is having trouble articulating to the attorney what all has happened in her relationship, or coming up with a way to describe it to the court. Brainstorming witnesses and evidence, dealing with trauma symptoms and preparing for trial. I'm not kidding about going to the courthouse. You have been there more times than your survivor has in a lot of situations. And it feels very, very different when you are the one who's going to have your information put before a judge. So, you've got connections there. See if someone can let you into an unused courtroom. Practice, where is she going to meet her attorney before the hearing starts? Go and look at the computer that they use for e-filing, right? And then supporting peripheral needs. So maybe she's struggling with her employer because she has to take a couple of days off work for the trial, right? Is there something she needs from the attorney? Is there something that you can provide to help the employer understand what's going on so that she doesn't lose her job? All kinds of stuff there. Okay, so let's look at some examples again. So how many of you have worked with a survivor who comes in and tells you that their attorney is a jerk, who doesn't understand what's going on, and is doing a terrible job? You got to help her find a new attorney. Have people had a survivor with that issue?
Nicole says yes. Happens often.
Yeah. Um, okay. I get those calls too. Survivors call me because they think their current attorney sucks. Um, so here's our example for today. Sylvia has an attorney helping with her divorce and custody case. She feels her attorney does not understand DV, and the attorney isn't using Sylvia's evidence of taped conversations with the abuser, photos of his collection of whiskey bottles. She called her attorney 3 times this week and hasn't gotten a call back. The attorney says she doesn't want Sylvia to talk to the court about her suspicion that the abuser was drugging her. So what sorts of things can you do for Sylvia that are advocacy, that will be helpful to her? What have you done in the past for survivors who come to you with this issue? Well, I'm guessing one thing that you do if survivors come to you and tell you their attorney sucks is validation, right? You support them, you ask questions to understand what's happening, and you validate that the survivor is feeling silenced, that the court process has a lot of limitations and is not always built to be the platform that survivors want it to be.
We have a response from Taylor, a couple responses. Our first
Okay.
response from Taylor is we can ask Sylvia if she has asked for further explanation on why her attorney doesn't want to be discussed, so she may understand it better, and we can go with them to the appointment with the attorney they want.
Great. Those are great suggestions, Taylor. Yes. So, sorry, I've got too many windows navigating here. Um, Part of this is a little bit of a judgment call. It takes a little bit of critical thinking, which is a challenge because as an advocate, our role is to accept what the survivor is giving us and reflect it back, and not to say, like, I don't really believe you about that. But I want to encourage you to help a survivor work with an attorney if she has one, rather than steering her to get a new one.
We have a response from Jody, Liz. Jody writes, we can talk about what her options are regarding calling the attorney or not, and talk about what Sylvia thinks about each option. If Sylvia feels the attorney isn't working, talking about her goals and what options she has.
Great. Yes, Jody, those are great great ideas. Um, so a lot of times, survivors who I have had come to me with this kind of question, I think benefit a lot from having somebody help them nail down what is it about your interaction with your attorney that's making you feel like they're not hearing you, that they're not behaving in the way that you want them to. And then trying to give them language and ways of returning to the attorney and saying, expressing what they're feeling, trying to improve that communication between survivor and attorney. Because like I was saying, in a lot of cases, even a less than stellar attorney is going to be better than no attorney at all. It's going to be really hard for a survivor, for anyone, to find a new attorney while they're still represented by somebody else. And often attorneys feel like the client is going to be less forthcoming with the second attorney because that trust has already been broken once. And so a lot of attorneys are really nervous, really cautious about taking cases where someone has already been working with an attorney. It's also, as a professional presentation thing, it's in poor taste for me to backseat drive someone else's case. Particularly divorce and custody cases, like I said, are so very fact dependent that an attorney needs to be knee deep in it before they can see what their options are for presenting a case to a court, and to know whether something is a good decision or a bad decision. But the attorney, whoever it is, should absolutely be communicating with the survivor to help that survivor understand why certain decisions were made, and what's going on, why they're using certain things and they're not using others. So exactly like you have suggested, you're going to talk with Sylvia about going back to her attorney and asking why the attorney isn't using those pieces of evidence, asking why the attorney doesn't want her talking to the court about her suspicions that she was drugged. How I often explain it to survivors is that part of an attorney's job is to have a strategy about how they're presenting a case to the court. And that part of that strategy is deciding which pieces of evidence come in and which pieces they're not going to use, deciding what's going to be most meaningful to the court. And it is entirely okay for a survivor to go back to her attorney and say, what's the strategy here? To assume that the attorney has a strategy and that's why she's not using the evidence of the taped conversations, but that the survivor wants an explanation of why. Because we also know that as people who work with trauma survivors that, the reason that taped evidence is really important to Sylvia. Did you just lose my slideshow? Anyway, the reason that is really important to Sylvia may be, very personal, may be related to traumatic experiences, but from the attorney's strategic standpoint on the case, it may not be very effective at communicating what Sylvia wants the court to know. Or it may be that in this particular case, a history of DV or the issues that are presented there are peripheral. They don't actually impact what's before the court. It all depends. Okay. Sorry, we're not going as fast as we can. Other things that you can do as an advocate are help maintain realistic expectations here. So Sylvia is saying she's called her attorney 3 times this week and hasn't gotten a call back. Slow up a little bit there, Sylvia. Attorneys have other cases and other projects that they'll be working on. If it's a true emergency, the survivor needs to articulate that so the attorney knows and can respond appropriately. Otherwise, help the client think through effective communication. It's absolutely a hoop fence issue, but sometimes less is more, right? The clients who are easier to talk to, who aren't constantly hammering with calls and questions and dragging on time, the attorney is going to be more likely to pick up the phone. Even though it's not right, it's true. That's another place where helping a survivor prioritize her issues can be useful. So, rather than calling 3 times in a week because 3 different issues popped into her mind, help Sylvia start a running list. And maybe she schedules a call once a week or once every 2 weeks with the attorney. And before that call, you sit down and look at her running list and help her decide what are the top 3 issues that you want to make sure the attorney addresses. And then, that will help that phone call go better. Also, help Sylvia think through if she's paying for an attorney, every time she calls that attorney and gets a call back is going to cost her money. Every time she sends an email and the attorney has to read the email is going to cost her money, let alone when the attorney then has to respond. So it's more cost effective for those phone calls to be condensed. Okay, so what would be over the line with Sylvia? Some examples. Recognize that you don't know the rules of evidence and they're really complicated. So you can't tell Sylvia, like, those taped conversations are hearsay, they can't come in. Hearsay is really complicated and has a different place in family law than in other cases. What you can do is tell Sylvia that there are rules of evidence, and sometimes some things are not allowed to be used in court. Other things can be. Um, that it's going to be part of that attorney's strategy to decide which things they'll use and which they won't. And then to encourage Sylvia to ask questions about, what's going on. You can't call the attorney yourself on Sylvia's. If the attorney is ICADVA, if it's one of us, and we already have that relationship where you're working with the survivor, we may have a release from the survivor to be able to talk with you. But generally speaking, an attorney can't talk to anybody else about a client's case. They can only talk to the client. So you calling the attorney is not going to be very effective, and the attorney may tell you that you're doing unauthorized practice of law, telling your client what needs to happen. What you can do is have the client call from your office so that you're there to help her understand, to slow down the conversation if the client's not understanding what the attorney is saying, anything like that. If you do that, make sure the attorney knows that you're there so that A, they're not surprised, and B, they can talk to their client about confidentiality issues if that's a concern. Don't tell her to get a new attorney because this one sucks. Like I said, there's a strategy going on. It's going to be hard for her to get a new attorney, and you don't necessarily know whether this attorney is doing a bad job or not. You may strongly suspect. That is very possible. And if you have that strong suspicion, you can help Sylvia look up how to file an ethical complaint against her attorney at the close of her case if things go very poorly. But it's more useful to help Sylvia have effective communication with her current attorney rather than telling her to get a new one. Okay. Next situation. Let's say you have a client who's working with an attorney on both a U visa immigration claim and a divorce. He doesn't understand some of the questions in the U visa form. There are some about whether he knows anyone in jail or whether he was present when an assault was occurred. His attorney is asking for copies of lots of bills and his apartment lease. He thinks there's a hearing next week about temporary custody or something, but he's not sure. So help, please, right? Salome is going to do another Lunch and Learn topic specifically about immigration forms. So stay tuned for more guidance there. Anyone want to chime in with advocacy ideas for Jose before I push on? Because I know I've gone long here. Okay. At a basic level, if the client is asking for your help with immigration forms, you can do that. The language in the forms is really tricky. So if English is not that person's first language, Jose doesn't speak English as a primary language, translation, just understanding the forms is great. We are working at the ICAVA clinic. We're working on a program that will help with a more official translation of the documents, but we're not quite there yet. Even if English is the survivor's first language, some of the vocabulary in those forms is really complex and, rarely used kinds of words. So someone may still need help with the forms. Similarly, you can write down what the survivor tells you is the answer exactly as the survivor tells it to you. If there's any additional description or questions, you can write that down and attach it. The attorney will sort out what's needed and what's not. Okay, so if you are just recording the information for the survivor, you are not practicing law. You are just transcribing. What's really important about that is the relationship that you've built with the survivor can make that process really helpful and really useful. Sometimes survivors are nervous about disclosing certain things to the attorney because they think we'll stop helping. So don't assume that we already know information about an answer on a form. And please don't tell the survivor that we don't need to know. Encourage the survivor to share those details. If you have been doing this long enough and have some history, you could say something like, in the past, I don't think that issue has affected the process, but let's write it down and we'll ask your attorney. So you can do some of that validation, some of that emotional support while helping to build that relationship with the attorney. Helping a survivor gather documents, we know, particularly in immigration cases and also in divorce cases, that there is a ridiculous amount of paperwork that needs to be gathered as evidence. And with survivors with trauma issues, it can be overwhelming, and people can get stuck before they even get started. So if you can help someone navigate a website or make a call to a landlord or something like that to get copies of documents that we need for evidence, that's really helpful. Or calling police departments to get copies of police reports or 911 calls or any of that. If the survivor doesn't understand what's happening in his case or why the attorney needs certain documents, help the survivor come up with questions to ask. I would much rather explain something twice than miss an important piece of information. Unfortunately, you cannot tell him like what to include or what not to include in an affidavit. I think I'm jumping in my notes. But so let's say he has a temporary matters hearing next week, he thinks. How do you figure that out? If it's a divorce case, it will not show up yet on Iowa Courts Online. Divorces are confidential until they are finalized. If it's just a custody case, if the parties were never married, then Iowa Courts Online should list what happens next in the process, what's been ordered. Regardless, either case, an attorney should be giving the client copies of any orders that come from the court, any motions or paperwork that the attorney files with the court. So ask the client if they have any of that paperwork, and you can help the client read through it and see if there's comprehension issues with the language. And if the client doesn't have copies of that paperwork, let the client know. They can call and request that from their attorney. That's their right as a client to know what's happening with their case. Things that are, you can also attend, right? So Jose thinks he has temporary matters. Does he need to show up? Ask his attorney. Does he want you to be there? If he wants you there, you can go with. You can sit within, most of the time you don't go before a judge, but you can sit out in the courtroom or in the courthouse hallway and be there for that emotional support. That's immensely important. Things that go over the line, you cannot fill out the form based on your prior knowledge of the survivor. So, go sit over there, I'll fill this out, won't work. The survivor has to direct the disclosure of information. You can always remind someone if they forget a piece of information that you know from your relationship with them. That's very helpful to have multiple brains, multiple memories working on this. You can suggest, hey, what about that time? Okay. Questions there? Okay. So then our last example is pro se clients. This may be where you're most tempted to go over the line when you have a survivor who's floundering, someone who's headed to trial all by herself. So tread lightly. This is going to be the trickiest spot. You can connect the survivor with reputable pro se resources. I've got some links at the end of the webinar here. Help her create a priority list. What does she most want the court to know? What does she want the court to do with that information? What is she asking? How does she want the court to respond? Help her brainstorm options, witnesses, think through what the other side might do. So not only does she have to plan for her case, but she has to think through what's the other side going to do. So what's the worst thing he could say about her that's true? Of the untrue things that he has said about her in the past. What did he say when he really wanted to hurt her? Right? Those are good questions to help her think through in her memory from her knowledge of her relationship with the abuser, and then to plan through how she's going to address those things. You can role play a little bit to have her practice language of how do I ask this question that I want to ask? how do I frame, what words do I use to express my experience that I want the court to know? So here's our example. Joy is pro se because she can't afford an attorney. She has the final custody hearing in 2 weeks against Frank. He is the father of her 4-year-old twin girls. Sadly, Joy attempted suicide when the girls were 4 months old. Since separating from Frank 2 years ago, she's seen a therapist monthly and she's been on antidepressants. The girls have lived with Joy since she left Frank. He wasn't interested in visits until she asked for child support, and then he got an attorney. The girls take swim lessons at the Y, and they go to daycare at Little Tots when Joy works. All right, so this probably looks familiar to you as well, right? Someone who has tried to get an attorney but wasn't able to get one. She has to move forward anyway, and now it's down to the 0 hour. It's the trial. Survivor is terrified, overwhelmed, and looking to you for help. And it's also very common that survivors have something in their past that they're very afraid is going to come up and is going to tip the balance and make them lose. So number one thing you can do to help Joy in this situation, coping skills, right? She is going to be in the courtroom, and not only is she going to have all the stress and all the trauma of being the person whose life is put before the court, she also has to serve as her attorney, which is its own scary and daunting thing. So help her frame this. In Joy's case, she's been raising twin girls on her own for 2 years. She can handle this, right? So practice managing trauma reactions, staying focused when Frank or his attorney go on the attack with questions. Let her know that the judge shouldn't let the attorney get too awful, but even there's a certain level of poking that an attorney or the opposing party is able to do that's allowed. Just asking snide questions and things like that. And it's going to be hard to answer questions that are emotionally triggering at the same time that she's trying to plan her own case and her own response. So it's imperative that she not dissociate, that she not get too emotional, something that gets in the way of her concentration, and like she can't get so angry that she stops thinking, right? So working with the survivor to anticipate what her emotional reaction is going to be so she can manage that and move forward with her plans is a huge thing. You can brainstorm what she's afraid he's going to bring up, right? Make a list. Think through when do you want to address this? Do you want to address it before or after he brings it up? What do you want to do to address it? How do you want to show the court this doesn't matter, right? She has to be in charge of those decisions. She has to be steering her own case, but you can help her make the checklist and walk through those issues, okay?
Elizabeth, Nicole writes, it could be as simple as going with her to the court for support.
Absolutely. That is a very important thing. So if you have someone who's pro se, part of what's tricky is she is going to, there won't be someone asking her questions when she's on the stand. She will still be up on the stand and giving the court information, but there's not someone asking her questions to help her remember all of the pieces, or to direct her testimony. She'll just be sitting there and prattling on. It probably feels like giving a webinar where you're speaking into a void. And so having someone she can look at who is a safe person, who's giving her nonverbal encouragement that's not witness tampering, but is just like, you're doing it, that's really important. That's huge. And being able to decompress during breaks. Yes, great suggestion. You can help Joy brainstorm evidence and witnesses. So like in this case, the girls take swim lessons. Okay, are there other parents that she's met at those swim lessons? Who's the instructor? How often do they go? Is that someone who could talk about Joy as a parent? Joy takes the girls to daycare, right? So Can the daycare providers talk about that the girls are always clean, well cared for, that they seem bonded with joy? Does Dad Frank ever show up to drop the girls off or call to see what they're doing? Um, so that level of question is probably more than you can suggest as an advocate. But what you could do is, if you're thinking through those sorts of things in your own head, is suggest to Joy, what is it that you do with your girls during the day? What sorts of things are they involved with? Are there people there who would be helpful? What sorts of information do you think those people would have? Right? So you're asking these broader questions that help Joy look at the big picture, look at the full spectrum of her life and what she could bring into the court to illustrate what she wants the court to see. Okay. Yeah. So this is another place where like role playing might be helpful for Joy. Like I said, when someone's pro se, they have to just get up on the stand and start talking. So having her practice, what are you going to say? What are the things that you want to make sure the court hears? What are you going to kick yourself for the next day if you forget to tell the judge? And then as she's practicing, as she's telling you those things, you can sort of give her feedback. Like, I can understand why that particular thing is important to you because I know your history. What can you tell the court to give them a little more context? And you can help with cross-examination. So maybe Joy comes up with the things that she's most afraid of. Frank's gonna ask me questions about the suicide attempt. Okay, so ask her some pokey questions. Be an asshole. So if she can handle the extremes, then she can probably handle some of the more methodical chipping away that happens in cross-examination. That is a challenging thing to do because you don't want to you don't know for sure what the other attorney is going to do for cross. You don't know. You don't want to lull her into a sense of she's knows exactly what they're going to say. But if she has come up with some of those topics, then ask her a question so she can practice managing her trauma symptoms and practice marshaling her words to be able to respond. Things that are going over the line. You can't tell Joy which witnesses to call. She has to decide who's important. You can remind her that time is short and that she'll need to prioritize. So she then, thinking through how much time it's going to take, which witnesses are most important to you. You can't write questions for Joy. So you can't write down what she needs to say in her testimony. You can't write down what she should ask the other people. But you can remind her of things that you've talked about or think through, why did you want to bring this witness? Why is this person important to your case? You can't tell her what to ask for. She wants supervised visits. Maybe you think she's never in a million years going to get supervised visits. You can't really tell her that. You can tell her that in your experience, you've seen that the court wants a really good reason for supervised visits. And then she has to figure out what she wants to do with that information. And you can remind her to have a plan B. So the court's going to ask her what she wants to see. And if the court says no, what's her second offer? Okay. Reputable resources. So these are also very useful if you have someone who's pro se, or even if you have someone who's working with an attorney and you're wanting to check and make sure that they understand the information the attorney is giving them. So Iowa Legal Aid has a whole library where they have short articles describing different elements of cases. So they have things that define custody, define different kinds of custody, joint, shared, sole. And they have the whole range of issues that Iowa Legal Aid helps with, they have topics about. So if you have someone with a tort suit, someone with a discrimination suit, there will be issues there to help describe that process. The Iowa Judicial Branch also has a guide for representing yourself in court that walks through some of the basics. You know, what does it mean to be a plaintiff and respondent? What should I wear to court? There's information like that in the Representing Yourself in Court guide that your client can read, and then it's not legal advice. Similarly, you can direct your client, if they're representing themselves, there are forms on the Judicial Branch page to help with starting certain processes and then going through the process. So pro se divorce, there's forms there, child support issues, custody. So check out that link. ICODVA, we also developed a housing law guide a couple years ago when we were going through transition that walks through the different landlord-tenant rights and has some samples of, you know, what does a notice look like when someone's evicted? What has to be in it? How do I respond if notice is not proper? I know we've sent it to the listserv before. If you want another copy of it, let us know. I didn't know how to hyperlink to it in the webinar. Oh, maybe I'll add it to the handouts. Hey, thinking. Okay, so I know we ran a little long. Thanks. Wow, really long. Thank you for hanging with me. I hope this was useful. If you have questions, please write them in the question box or type them in the chat, and I will see if I can help you real quick.
We're going to open the Q&A portion, so go ahead and you can submit those via the question pane, or you can raise your hand and you can ask that question through audio. Nicole had a comment. She says, great webinar.
Great. I'm glad it was useful.
So if you have questions, go ahead and ask those through the chat pane, or you can raise your hand and ask those via audio over the system. Elizabeth, do you have your contact information available?
I do. So let me jump back here. Ooh. So my phone number and email are on this slide here, which is in the handouts. Feel free to call me, send me an email if you have questions. Like I said, I can't backseat drive someone else's case, but I am more than happy to help you with general TA questions if you want to understand, you know, what the process looks like. If you have a hypothetical scenario and you want to walk through, hypothetically, what would Sarah need to do in this case? Talk to me, and I can give you some parameters around that too.
All right. I want to thank Elizabeth, and I want to thank everybody for attending today's webinar. I am no lawyer, but if you have any other questions, please contact Elizabeth Albright Battles at the information that's on the screen. Once you leave today's webinar, you will receive a survey on the presentation. We would appreciate it if you'd complete and provide the feedback. You'll receive the email, follow-up email with almost directly after we're done with the webinar. On behalf of myself, the Iowa Coalition Against Domestic Violence, and our presenter, Elizabeth Albright Battles, thank you for joining us today, and have a great rest of your day. This ends today's webinar.